All right, good afternoon, everyone. It's now 1 o'clock, so we're going to get started. So welcome and thank you for attending the second installment of Gowling WLG's M&A webinar series, M&A in Uncertain Times. Today, our panel will discuss how you can use the economic slowdown caused by COVID-19 to get your house in order if you're contemplating selling your business in the future or as a matter of good practice generally. Our first installment aired last week on how the disruptive effect of COVID-19 is impacting M&A transactions in Canada at different points in the deal lifecycle. If you missed the first webinar in our series, an on-demand version has been posted to our website. But before we get started, just a few housekeeping points. To view the presentation on all speakers, please click on the speaker view in the upper right-hand corner of your screen. For questions throughout the session, please use the Q&A button at the bottom of your screen. We'll try our best to answer questions at the end of the session, and you should feel free to reach out to our team afterwards as well. This presentation is also being recorded and will be posted on our website in a few days. It also counts for 1 hour of continuing professional development. For example, in the case of Ontario, it counts for 1 hour of substantive credits towards the mandatory annual CPD requirements of the Law Society of Ontario. And it wouldn't be a law firm webinar without a legal disclaimer. So as you expect, today's session is a high-level overview. For any specific advice, please contact your legal counsel. As you know, this situation is extremely fluid and changing daily. So now to our panel. Participating in today's session are one of our tax partners, Ted Thiessen, and 3 of our M&A lawyers, Melanie Condick, Marcus Hinckley, and Lorraine Mastersmith. And I am Karen Hennessy. I'm also an M&A lawyer, and I'll be moderating the discussion today. So turning to our agenda, our plan today is to discuss a number of actions that a seller or a target business can take to make the deal process run smoothly. We know that in many mid-market M&A deals, the sellers of a business may not have been through a transaction before and may be overwhelmed by the amount of diligence requests, calls, and documents to collect and review. Typically, it's the founders and key employees of a business that are charged with coordinating the diligence requests and managing the sale. But these are the same people who are trying to run the business and are working full-time doing so. This often results in a dip in financial performance at a time when the target company is being financially evaluated and the purchase price is being negotiated. Our suggestion is for business owners to use this slowdown in operations to organize the company's affairs and ensure a smoother and more efficient diligence period. We'll also provide some practical examples of what can happen if the target is not prepared, and then provide practical and easy tips on how to prepare your business for sale. We will discuss steps that can be taken to ensure a tax-efficient sale from the seller's perspective, including how to minimize tax payable on the sale proceeds, and also how to anticipate and be proactive on the items that a buyer will be most interested in during the due diligence phase. This is a moderated discussion, so we're now going to take down the slides so that the panelists are more prominent in your screen. And my first question is for each of the panelists, and ask you to set the stage and provide some context. Perhaps tell a story or even a horror story of a deal that you've worked on that may not have gone as the seller planned, and how the seller could have mitigated that issue. So Melanie, can I start with you?
Sure, Karen. I think we can all speak about transactions that have been derailed by items that have come up during the due diligence process. Something all sellers need to be conscious of is that this is the buyer's look at their company. The review of these records will impact the buyer's view of how the business is being run. So the seller using its resources on the front end can be really beneficial, especially if it's doing it while they're not under a time crunch. For example, I had one file last year that died at the due diligence phase, mostly because the records of the seller were a mess. The data room was basically a data dump that we had to try to make sense of. In this transaction, the seller ran a pharmaceutical business and the buyer was interested in some of its key patents. When we were given access to the data room, the records were really unorganized. There was a ton of material. Most of it was haphazardly placed in different folders in the data room. There were several duplicates of the documents. We had also discovered pieces of a historical reorganization that we weren't told about. So we had to try to puzzle all these pieces together to understand the chain of title to these IP assets. But because everything wasn't there and the seller themselves couldn't give us a roadmap to the company's history, along with all these missing links between all the documentation, the state of these records made it too risky for our client to proceed at their original price point, and the seller themselves wasn't willing to come down. Had the seller in that instance taken the time upfront to organize those records so that they could address those missing links by either filling them in or explaining what had happened, the transaction might not have fallen apart.
Hi everyone, Marcus here. Thanks for joining us today. So in my experience, I've found that whenever a regulatory license or permit's involved, it can potentially delay a transaction, and this can sometimes be quite significant if the seller's not organized. One particular example that comes to mind is a deal that involved products that were defense related, and they were therefore registered under the Canadian Controlled Goods Program. During the diligence process, we were acting for the buyer, who was a large US client of ours, and we had asked the target, do you have any products that are registered under the Controlled Goods Program here in Canada, or is there anything registered under the International Traffic in Arms Regulations in the US, or ITAR, some of you may know. The target wasn't really sure if they had any of these registrations, and it wasn't until signing the deal that they realized that they had and produced the relevant documents. This required us to delay the transaction and to provide a 45-day window to allow for a pre-transaction notification under the Investment Canada Act. And then we had to add a closing condition for the approval of the Investment Review Division. So, you know, something else to bear in mind there is, had a national security review have been ordered by the government, then this would have delayed closing by up to a further 200 days. So it just highlights that knowing whether there are any regulatory hurdles at the outcome of a transaction can really help the parties allocate the risk and plan the transaction accordingly.
Yeah, and so, hi everybody, I'm Ted. So I'll talk a little bit about tax stuff today. And I can give an example, certainly, of something that I see fairly often. And although a lot of business owners are generally aware of the existence of the lifetime capital gains exemption, it's a much smaller subset of those people that might be more familiar with what the actual conditions that need to be met in order to take advantage of that exemption are. And there are several conditions. I won't be able to discuss all of them today because there are so many and they're so detailed that that can be the subject of its own webinar. But two conditions that often come as a surprise to business owners are: one, they need to own the shares directly in order for the capital gain to qualify for the exemption. And second, they need to have held the shares for at least 2 years prior to sale. So for business owners that utilize a structure where they hold shares in a holding company that in turn holds shares in an operating company, those two conditions that I just mentioned can cause some last minute scrambling, particularly if the holding structure was put in place less than 2 years prior to the sale. For example, a buyer, for reasons that we'll touch on later when we talk about due diligence, is rarely going to be interested in acquiring a holding company with an operating company underneath it. They almost always want to acquire the operating company only. So for a business owner that holds their operating company indirectly through a holdco, a sale of the operating company by the holding company wouldn't be sheltered typically by the capital gains exemption. So even if the business owner can convince the buyer to purchase the holdco shares, that sale can only benefit from the exemption if the business owner has held the shares of the holdco for more than 2 years, which can be a problem for buyers that put a holding structure in place and then before the 2-year period is up, they decide to sell. So how could those issues have been mitigated? It's important to remember that you need to have the end goal in mind. So depending on the nature of your business, if the most likely exit event is a sale, then ideally you should periodically be talking to your tax advisor to get a sense of what that might look like given your current structure. It's easy to get caught up in the day-to-day running of your business, but periodically checking in with your advisor to discuss options well in advance of an exit event, when you actually have the luxury of time to think about them, is always going to be the best mitigation strategy.
That's great. Thanks, Ted. This is Lorraine. Hi, everyone. Building on what Ted has just described, I've been involved in numerous transactions where a pre-transaction reorganization of the seller has resulted in delays. From a corporate perspective, these reorganizations can involve layers of holding companies and trusts. And when they're done late in a transaction, which is often the case, they result in additional late-stage due diligence requirements, and substantive revisions will need to be made to the purchase agreement. The parties will have changed from what was initially contemplated, and therefore you're going to have to make some changes to the purchase agreement, and the parties are going to have to contemplate what further due diligence would need to be done on those other entities that have been interposed into the transaction. So I've seen these types of circumstances prolong closing by several months. And so, as Ted said, if you put these tax efficient structures in place prior to negotiating the terms of a sale, those types of delays can be easily avoided. Also, following on to what Marcus had to say, particularly in respect of businesses that are contractors or subcontractors to companies with government contracts, I've been involved in several transactions where closing's been delayed due to matters that could have been dealt with by the seller in advance. One in particular that comes to mind involved compliance by the seller with provisions in its material contracts relating to government procurement policies. Concerns in this regard only came to light during the due diligence process, and the buyer ended up modifying the reps and warranties that they had included in the purchase agreement as a result of its diligence findings. The seller then had to go back and conduct an internal analysis to determine whether or not it was complying with the terms of its material contracts. And then it had to take steps to modify its business practices to ensure that it could provide the representation required by the purchaser in the agreement. Had an internal review of the seller's compliance with these contractual requirements been undertaken prior to the transaction negotiations, this would have prevented the delay that was caused by the seller's need to conduct that internal analysis, and they would have been in a position to propose acceptable qualifications to the reps that were required by the purchaser.
Great, thanks everyone. Ted, you mentioned a client not being able to take advantage of the capital gains exemption and how with advanced planning that client could have fared much better from a tax perspective. Lorraine also mentioned tax issues relating to a company's corporate structure. Can you give us any other tips on how a seller or a company can prepare now to minimize tax payable on the proceeds of a sale?
Yeah, sure. Thanks, Karen. So a few things. In terms of reducing tax liability on a sale, it might make sense to incorporate if you haven't already, because quite apart from the liability concerns that often drive the incorporation decision, incorporation can have tax benefits if a sale is going to be the likely exit event. And that's because a share sale is generally going to be taxed as a capital gain. And when you compare that to the sale of assets of an unincorporated business, particularly one that's been operating for a long time, that type of sale would typically give rise to recapture. So, and recapture is taxed at a higher rate than capital gains are taxed. You can usually move the assets of an unincorporated business into a corporation on a tax deferred basis, so it can typically be done without incurring an upfront tax cost or a cash cost. Assuming you're already incorporated, you might want to think about issuing shares to your spouse or other family members to the extent you haven't already. Freeze transactions can be implemented to allow that to happen without requiring significant capital injections. And the benefit, obviously, is that spreading the sale proceeds over more shareholders will generally reduce the overall tax rate payable on the sale. And to go back to the capital gains exemption for a minute, one of the other conditions that you have to meet for that exemption to be available is that during the 2 years you hold the shares, the assets of the company you're selling have to fit certain criteria. Generally speaking, 50% or more of those assets have to be used in an active business in Canada. So bad assets for purposes of that test might include, for example, things like passive investments or excess cash. So on a periodic basis, you're going to want to examine your company's assets and make sure that you're not offside the value requirements for the capital gains exemption. Because once you're offside, you have to get back onside before the 2-year clock can start running again, and you effectively restart the 2-year period. So purification transactions have been devised by tax advisors to help you make sure you meet the test, but you have to stay on top of it so that you're aware of when you might need to take remedial action.
Great, thanks, Ted. That's happened to one of my clients for sure, where they used the company and thought it was a good idea to put their investment portfolio in there. So it was a big surprise when they realized they didn't, that put them offside the test. So there was a lot of scrambling going on. So I think that it goes without saying that tax advice is critical to any business owner thinking about a sale. I want to move on now to issues that the seller may be concerned about. So we know that one of the first substantive steps that a buyer will undertake before committing to a purchase is due diligence. And I think it's fair to say that most business owners, in particular owners of small to medium-sized businesses, greatly underestimate the work involved in the diligence process. Lorraine, can you please describe the purpose of diligence and why a seller needs to be organized?
Sure, Karen. The purpose of due diligence is to provide the purchaser with information that's required for them to make a proper assessment of the business that they're buying. So the purchaser is going to want to know about the quality of the assets and the nature of the liabilities that it's going to assume when it takes ownership of the business. The information that's disclosed to the purchaser in the diligence process is then measured against the seller's reps and warranties in the purchase agreement. From the seller's perspective, going through this process informs whether or not they can make the requested representations, for example, compliance with its material contracts, which I mentioned earlier, and to ensure that appropriate qualifications are made to those representations where that's necessary. By taking the steps early in the process of readying the company for a sale to gather the information that's typically requested by a purchaser and reviewing the material contracts for compliance, the seller will find itself very much prepared to determine what representations it can provide and what qualifications might be needed, which will result in avoiding late stage surprises that could delay or closing or even become a deal breaker. The more organized a seller is in this regard, the greater confidence this is going to instill in the purchaser that the management of the company is on top of the business. This in turn could lead to the ability of the seller to negotiate lower earnout amounts or holdback amounts. And that means more cash in the seller's jeans on closing. All good reasons.
Yeah. That's the ultimate goal, cash in jeans. So we've discussed how selling shares of a business can have significant tax advantages for a seller. But before a buyer is going to commit to purchasing shares, one of the first things they're going to want to see, of course, is the company minute book. Melanie, can you talk about the importance of having the minute book in order?
For sure. As Lorraine had mentioned, being organized is key to any due diligence review, and having an organized and up-to-date minute book is one of the ways that the seller can show the buyer that they're on top of their business. The most critical part of these records for the buyer will be ensuring that there's a clean chain of title to the shares that they're potentially going to acquire. So if there's any deficiencies relating to the issuance of shares or the transfer of any shares, then you may be putting the deal in jeopardy. So even if you don't want to necessarily engage lawyers to fix issues right now, taking the time to identify any gaps, draft up a list of missing information such as missing share transfers, unrecorded share issuances, any contracts that the company's entered into or changes in management. By having that list, your life will be a lot easier when you do eventually work with your legal team to rectify the records. And the less of a time crunch you're on when you're doing this, the easier it is to be efficient. There are certain items that you may not even be aware that should be in your minute book. So if you're uncomfortable or uncertain about this, one of the items of value that you might consider is reaching out to your law firm and having a member of their corporate services team, one of the law clerks, complete a minute book review. This is a cost-efficient way to identify these issues, and it's easier to work from a deficiency list to start rectifying items. These clerks, are day in and day out in minute books, so they know what should be in them. They can point out then what common items are missing, such as your annual director and shareholder resolutions. If you have a multitude of unsigned resolutions or minutes that you need to go track down, whether there's original share certificates in the minute book or if there's just copies or there records of where those originals are. And finally, if there's shareholder agreements, because if there's a shareholder agreement, potentially that could impact the approvals and timing for your transaction. We were talking about this in the context of a share deal. And an asset deal, the seller will still want to look at the minute book because they'll want to see what approvals are necessary, but it might be on a lower priority than in the instance of a share deal. But as Tez mentioned, a share deal is usually more optimal for the seller. So you're going to want to ensure that those records are in order.
Great, thanks. So another key consideration in a deal is that a buyer is not only assuming the physical assets and contracts of a business, but they're also acquiring the business's workforce. Lorraine, what types of information is a seller typically interested in about a business's employees?
Thanks, Karen. A buyer is going to be keen to understand the makeup of your workforce in order to assess any potential liabilities, and they'll also want to begin their workforce planning for post-transaction. So you're going to need to be in a position to provide detailed information on all of your employees, particularly relating to things like salary, age, and the length of service of each employee. A purchaser is going to want to review all of the employment contracts you have in place and all employee handbooks and policies. And particularly if you're a technology company, buyers are going to want to ensure that you actually own all of your intellectual property. So in this regard, they'll want to ensure that all employees have signed contracts that assign to your company all of their rights in any intellectual property that they develop during the course of their employment. And buyer's counsel is going to be looking for specific language in these contracts that requires employees to waive all of their moral rights in any IP that they develop. Further, in the event that any past employees have been disgruntled on leaving the company, you should collect any facts and correspondence in relation to this, as the buyer is going to want to assess any risk of litigation and potential liability that might result from a departure of an employee.
Yeah, that's good, Lorraine. And just staying with the employee topic for a minute, on the tax side, the classification of workers as contractors versus employees can often be a thorny due diligence issue. And that's because of what we've been talking about here, which is the fundamental difference between an asset sale and a share sale, is that in a share sale, the buyer is going to be, quote unquote, inheriting all the liabilities of the company. So it's not, and a tax liability is going to be foremost in their minds. So it's not uncommon for small and medium-sized businesses to retain the services of a number of workers that they choose to categorize as contractors rather than employees. And because the employer categorizes them in that way, the employer doesn't withhold source deductions for income tax, doesn't withhold CPP or EI, and doesn't make CPP or EI contributions. And in some cases, the categorization that might have been agreed on between the employer and the particular worker doesn't necessarily hold up under close scrutiny. For example, regardless of the name that the employer and the worker decide to give to the relationship, if the worker doesn't work for anyone else, uses tools and space that are exclusively provided by the employer, and has no real control over what work he or she can accept or turn down, that worker might well be an employee and not a contractor for tax purposes, which would mean that the corporation should have been withholding income tax and CPP and EI in respect to that worker for who knows how long. So failure to withhold and remit source deductions can result in significant historic liability for taxes, premiums, interest, and penalties for the company. And a purchaser is going to want to make sure that workers have been properly characterized and that the appropriate source deductions have been withheld and the appropriate employer contributions have been made and remitted in respect of all of the target company's workers. So compiling supporting information regarding every worker that you're categorizing as a contractor is going to give the purchaser some comfort that you've been on top of it and there's no hidden tax liability that they might become responsible for post-closing.
Great, thanks Lorraine and Ted. So from my experience, the time-consuming part of the diligence process for sellers is the collection and organization of contracts. Melanie, can you talk about how a seller might go about organizing their material agreements and contracts?
Yeah, sure, Karen. So I would say that one of the more onerous tasks of the seller undertaking in due diligence is this organization of your material contracts. Essentially, the seller is going to need to sort through all its current agreements, take stock of them, figure out if there's any missing items or gaps in these agreements, such as an amendment that's missing or an unexecuted copy of a renewal. They're also going to want to know what contracts, or the buyer is going to want to know what contracts they're inheriting. So if you as a seller have a sense of what commitments you have to and from third parties, this knowledge can assist you at the negotiation phase in marketing the sale of your business, because you'll be able to speak to those issues, offhand. Having an organized database of these material agreements can also make it easier to answer potential questions from a buyer. And when it comes to the actual due diligence process, it makes it easier for the buyer to verify the information you've given them. And then as a seller, so one of the first steps you want to do is when you're going through these is identifying and sorting the types of contracts you have. So This might be supplier agreements, customer agreements, services agreements, real property leases, equipment leases, or, other industry-specific contracts. And then you're going to want to organize them accordingly. If you organize them by type of contract, it's going to be easier for you at the DD phase to parse through them to provide the buyer with what they'll want to see.
Thanks, Mel. So once all the contracts are organized, are there any particular clauses or provisions in the contracts that the seller should be reviewing or looking out for?
Yeah, so there's definitely some key provisions you're going to want to be looking for, particularly whether the transaction has the potential to trigger any obligations under these agreements. So, for example, a consent requirement from a third party. In the context of a share deal, this will typically be found under a change of control provision. And then if you're in an asset transaction, you're going to be more looking at the assignment provisions to see if that gets triggered. Assuming that you're compiling this information without actually knowing your deal structure, we'd recommend that when you are taking note of these clauses, it might be helpful to index some of the details about how you go about obtaining the consent, whether it be a change of control or an assignment. So, noting items such as like, who is the person that you contact? Is there any cost associated? Are they entitled to information such as about the buyer, such as the buyer's financial statements? And then what, if any, is any timing for consent? Because if you need to give 30 days notice, it's really important to know that ahead of time so that you can plan for that. I think what you need to remember as a seller is that these third parties don't have a vested interest in your transaction usually, and so they're not under the pressure to deliver the consents in a timely manner, and you're often at their mercy. So because this is your deliverable in under the transaction, if you do some of the legwork ahead of time, you'll have a sense of what kind of time and effort you might need to be putting into chasing these consents. I think the whole group can probably speak to instances where a third-party consent, either held up a transaction by a couple of days or a week or two, just because you couldn't get a hold of that landlord, or they were, it was just in their queue of emails and they'd get to it when they get to it. So, and then there's a couple other obligations that, may be within some of these agreements. So something like a right of first refusal or a right to terminate a contract upon a change of control. So if it, like, for example, if a material supplier to your business can terminate the contract within so many days of a change of control, or someone else under a contract has a right to buy one of your material assets before you're actually able to offer it for sale, it might be proactive to have some of the discussions with those third parties before you go ahead and negotiate a sale that has the potential of, being derailed because this third party, isn't going to consent to the transaction. And then finally, one item I think that sometimes gets overlooked by sellers is their confidentiality obligations under these agreements. You'll want to go through these and determine what you can and cannot disclose. It may be that you're able to disclose the material contract so long as the other party's under similar confidentiality obligations, which means you're probably going to have to sign up a non-disclosure agreement before you show any of these contracts to a third party. Sometimes there'll be more rigid confidentiality obligations where you're not, let's say, be able to disclose any identifiable information about the third party. In that instance, you may consider whether or not redacting some of that information then puts you in a position where you can disclose it. One thing we just want to caution with redactions is make sure that you actually use proper redaction software so that they can't reverse engineer the redaction. And then there are other circumstances, where you may not be able to disclose very much information about that agreement at all. So you just need to be very in tune with those items.
Yeah, I think they're all great points, Mel. I think just something that I'd like to add in here is that when you're reviewing these material contracts, it kind of builds a little bit about on what Lorraine was saying earlier on. You should be paying attention to whether these third parties are in the defense, cybersecurity industries, or even the healthcare industry in the current climate. And look at whether any of these customers are government bodies at municipal, provincial, or federal level. This is going to be particularly important if any potential buyer of your business is non-Canadian, as it may increase the risk of a national security review under the Investment Canada Act, and consequently could result in a delay to the closing and or pre-transactional filings to the government. So.
Yeah, those are great points, Marcus. And one further comment I'm thinking that is also important to keep in mind is, just building on both comments from Mel and Marcus, is that assuming your due diligence process is successful and your transaction is proceeding, one of the more onerous obligations you're going to face is preparing disclosure schedules. And that's used to qualify the representations and warranties that you're giving in the purchase and sale agreement. And one of those tasks will include preparing a list of material contracts of the company and likely a list of all the required consents. So if you've done the legwork that we've discussed, the process of populating these schedules is going to be far more cost efficient, and you'll avoid numerous hours of doing or paying your counsel to do a deep dive into all of the company's agreements when you're under other transactional pressures. So it's a really good idea to do these things when you have the time, painful as they may be.
That's great. So Marcus, I'm going to turn back to you as one of our tech-savvy lawyers. Any other thoughts on how to organize the contracts so that they're actually available and ready for a buyer to review as part of due diligence?
I mean, first of all, I think our head of IT would disagree with your tech-savvy comment. But yeah, I'm happy to talk through this. Something to bear in mind when collecting all of this information is that it's important that the documentation is in an electronic form and it's clearly labeled and organized in a coherent manner. This includes organizing the documents in folders and choosing a file name that makes it obvious what the document is. I'm a senior associate, and I can tell you from having spent the first 5+ years of my career in diligence data rooms that a well-organized data room is not only going to help reduce the legal fees, but it's going to make your legal team feel warm and fuzzy inside. So we've taken the approach with some of our clients to set up a data room for them based on our standard due diligence request list. And then we build in folders to reflect the questions we would typically ask for a seller. For instance, folders relating to employment agreements, material contracts, minute books, and other things. And then this allows the target company to organize its documents ahead of time using the numbering and folder structure already in place in our diligence request list. And means that when a sale transaction occurs, the target company is able to provide the data room details to the buyer, complete with a breakdown of what is included and where. So, an organized and complete data room allows for the buyer to feel comfortable that complete and accurate disclosure has been provided. And this can save time and money on both sides in negotiating the transaction. By eliminating as many questions on the buyer's diligence list as possible and providing the buyer with the detailed disclosure on the operations of the business, the risk of the representations and warranties in the purchase agreement being incorrect is lowered. And therefore, as a seller, you may be able to negotiate lower liability caps and reduced indemnification periods, or even receive more of the purchase price on closing by negotiating a lower earnout or holdback amounts.
Marcus, have you seen, we have lots of clients in Ottawa that are using artificial intelligence in their diligence process. Are you seeing the same thing in Toronto?
I mean, yeah, we have, Lorraine. We see clients on both sides of it, really, buy and sell side, utilize AI, especially in analyzing large batches of contracts. So, I mean, we use a system called Kira, which allows clients to drop in a large number of contracts, and then it will run a report to identify how many agreements have a change of control provision, for example, or assignment restrictions. And so, building on what Mel was saying earlier on, it's kind of handy to, ahead of time, figure out what you're working with. They can also turn your contract into searchable PDFs, which makes the kind of diligence process a little easier too. So we had a client in particular that dumped 500+ contracts into the system and asked it to produce a report outlining how many change of control, assignment, most favored nation, and exclusivity clauses existed in those agreements. And then this allowed the client to quickly and pretty cheaply weigh up what consents were required if it was going to sell the particular division of the business, and then which it later did. So, I think the use of AI and technology is extremely important, and I'd encourage anyone on the call today to talk to the legal counsel, or, if you don't have legal counsel, us, about setting up a data room and how you can use artificial intelligence to prepare your business for sale.
Thanks, Marcus. Those are great points, including one of the first ones you made, which seems very simple, but name your document so you know what it is. I recently worked on a deal where there were close to 1,000 agreements to review, but the data room, they scanned the agreement, and the name of it was just a numeric number that the scanner attributed to the agreement. So it was extremely frustrating. So and clearly increased legal costs because you didn't know who should review it until you opened it to see what the document was. So Lorraine, earlier you mentioned that potential purchasers are going to want to confirm that the seller owns its IP in the context of employees. But are there any other IP related matters a prospective seller should address when readying itself for a sale?
Yeah, for sure there are, Karen. The rights that a target company has in its intellectual property is a really important aspect of many transactions. In addition to taking the usual steps to protect the company's IP through its employment contracts, as I've mentioned, and the registration of trademarks and patents, of course, the company should also ascertain and document the additional steps it has taken to secure things like copyright and how it is managing its source code. The seller should review its license agreements with suppliers of technology that has been used in developing the seller's products. And this is really important where software forms a part of the company's product portfolio. The seller should really take steps to determine whether any of its products contain any open source software. Often sellers' management may not even be aware that open source has been used in the development of its products. Open source is a free, easy way for engineers to, on development teams to access and to incorporate into their development effort. It may often make things a lot easier for them. So, you know, time to market is always important in product development. So often, you know, these things may go overlooked until the time of a transaction. But this can come at significant cost to the company in a sale transaction. So any use of open source software in the development of products should be noted. The open source license should be reviewed, and particularly if open source is used in key products, the company should consider running scans on those products to identify vulnerabilities and quality risks so that those can be addressed in advance of commencing a diligence process. I've seen situations where the purchaser has requested a scan, identified open source in the seller's products, and the vulnerabilities and quality risks were identified in that diligence process, resulted in the negotiation of a reduced purchase price. So it's a really key thing for companies to consider.
Yeah, absolutely. That's great. Thank you. Marcus, earlier you talked about a deal that didn't go as planned. You talked about how regulatory issues can potentially delay or even derail a transaction. Why does this typically happen, and what can a seller do to mitigate the risk of that occurring?
Yeah, I mean, good question. I think, as I mentioned at the example at the beginning of the webinar, understanding the regulatory landscape that applies to a target company can be the difference between an efficient closing or a potentially lengthy closing period, or even a cancelled transaction if a closing condition isn't satisfied for the production of a regulatory permission from a government regulator. So pulling together submissions to regulatory bodies to notify them of a transaction, update information on public record, or to request consent to the transaction can often add significant time and effort to the closing process. And in particular, where a consent is required to allow the transaction to occur, the buyer will want the receipt of consent to be a condition to closing. Another factor to consider is that the Canadian government has the power to review any foreign investment, regardless of whether the transaction falls under the value thresholds for automatic review under the National Security Review powers contained in the Investment Canada Act. These powers allow the Canadian government to request additional information in relation to the transaction, the parties, and any shareholders of the parties, and conduct a thorough review of the transaction, which can delay it by up to 45 or even 200 days. So if the government finds that the transaction is injurious to national security, they can either block the transaction or allow it with certain strict conditions. Recently, it's been rare that these national security reviews have been triggered, but recently there's been an increase in the last few years. And in particular, if the target company operates in the defense, telecoms, cybersecurity, chemical, infrastructure, or utilities industries, there may be a heightened chance of national security review being ordered. So if your business operates in any of these industries, among others, then it's important that you understand your regulatory obligations early on in a transaction so the parties can plan around any foreign investment considerations. I mean, some of you may have seen over the weekend that the Canadian government actually announced that they're reviewing foreign investment transactions with even more scrutiny until the economy recovers from the effects of COVID-19. So, this really drives home the importance of using this economic slowdown to get to grips with your regulatory landscape and understand what your obligations are, especially if you anticipate selling the business to a foreign buyer.
Thanks, Marcus. I agree that these regulatory issues can impact a deal significantly. And, you know, as I mentioned before, we're always concerned with having to rely on third parties for any type of consent or response. So what do you see are practical things that a seller can do now to address these regulatory risks?
Yeah, I mean, good question again. I think there's a few things that I'd probably recommend. I mean, the first thing, identify who the applicable regulatory body is. So if you operate in banking, telecoms, money services, cannabis, pharmaceuticals, or defense, to name a few, then you're likely going to be subject to regulatory oversight. Typical bodies, OSFI, the CRTC, FINTRAC, Health Canada, or Public Services and Procurement Canada. So you should really nail down who the applicable regulator is. This also applies if you import and export goods. It's something which is commonly overlooked too. We find out that in a number of deals I've worked on that clients have been importing and exporting stuff and then figure out that they need a permit to do it. So second, locate the permits, certificates, or registrations that you have with those regulators and save an electronic copy. You should also be noting whether the permit is in good standing, has expired, or is about to expire, because from experience, finding out last minute that you need to renew a license or that it's about to expire can potentially delay or even derail a transaction if it takes a long time to get them up and running. You know, these are fundamental items in the operation of the business. So any consent from a regulator, you know, is going to be required likely to complete the transaction. Third, some regulatory bodies, including Health Canada and Public Services and Procurement Canada, when you're dealing with controlled goods and defense-related issues, require that a company has certain individuals or an individual, which is typically an officer or a director, have stringent security assessments conducted so they're security cleared. Now, it's important to identify these people at the outset and understand how long they've had these permissions, because the buyer, as is typical, may anticipate when they buy the business of replacing the whole board of the target entity post-closing. And if they do that, they may inadvertently invalidate the regulatory permit the business needs to operate. So by identifying the issue early, both the parties can plan accordingly, whether it be deciding to keep the individual in place or replace them with someone else of the buyer's choosing. Now, I mean, of course, the buyer may not have someone that can step in and that's been security cleared. So if that's going to take too long to get someone security cleared and they don't have anybody, you know, often they have to turn around to the individual in question and negotiate with them to stay on post-closing, which obviously changes the deal dynamics. So again, it's all about being prepared. And I think the fourth thing I'd recommend is once you've identified the first three things, so what the regulatory license are, you know, what regulatory licenses you need to operate, you've found the copies of the licenses, you've confirmed who the regulator is, and you've identified any individuals with specific permissions, it's then a good time to pick up the phone to legal counsel and then speak with the regulator on an anonymous basis and find out what the steps are in order for you, if there's a change of control event, you know, finding out what you need to do ahead of time. It really can help you start preparing the necessary documentation, which again, there's a common theme in this webinar. These things take time and effort. And the more you've done on your own legwork before, you know, you involve legal counsel and the buyers involved, it can save a lot of time and money. I think ultimately, unless it's your birthday, no one really likes a surprise. And so the aim of any regulatory considerations is to try and identify, one, what the regulatory permissions the target has, and two, what needs to happen in relation to those permissions as a result of the sale transaction. As mentioned, these things add a lot of time and complexity, and so and they could trigger Investment Canada issues, which is a whole nother ball game. So the earlier that you know these things, the earlier that the buyers and the sellers can begin dealing with them, and this can help reduce the interim period between signing and closing, and ultimately increase deal certainty.
I agree, Marcus, particularly on the not really liking surprises, particularly in a deal context. I do think that, you know, one bigger picture consideration for sellers to have is that in the regulatory context, not every buyer is going to have the familiarity that you do with your own regulator in your industry. So if you do have a sense of what kind of information the regulator is going to need from the buyer to process any approvals, you know, whether at that company level or the individual level, then you can take this opportunity to be prepared to educate the buyer if they are unfamiliar with the industry, and then the two of you can work together in order to get the relevant information in front of the regulator.
So thank you all, that was great. So Lorraine, in many cases, the target business may have outstanding loans to a financial institution or other lender. And just like all the other third parties that we talked about, dealing with lenders can add complexity and delays to a transaction. What are your thoughts on things that a seller can do in advance to minimize such delays?
Sure. There's a number of things that a seller can do. If the business has existing debt, then a buyer is going to want to understand the impact any sale might have on your financing arrangements. Most loan documentation is going to require the lender's consent to have any change of control in the company or an assignment of its material assets. There may also be prepayment penalties involved if the intention is to pay out all existing indebtedness on closing. So you'll want to know that ahead of time. To minimize potential delays, a seller can have searches run against both the company and its shareholders. And it's important to run those searches against shareholders as well as the company because you may not be aware that some of your shareholders might have a lien against their shares that they hold that may be prohibited under your shareholders agreement, but you never know until you run the search what the facts are. So good to know that ahead of time. So you want to run those searches, make sure that you're aware of all the liens, review your contracts with your lenders, and determine what consent requirements are required, how much notification is required. And ideally, if you can notify your lenders in advance that you are making plans, you may not have a deal on the table, but maybe you're acting with foresight and trying to get ready, and your lenders are going to appreciate that that you're being upfront and trying to be organized in this regard. So you know, if you take the step to potentially notify them in advance that you have plans, and that then you can work with your lenders to ensure that you understand what the requirements are. You're on the radar screen for in terms of a timing perspective of when you might need that consent, and you have all that done well in advance of closing. And then you've got a plan that's put in place to deal with these things, and they'll be dealt with in a more expedited fashion.
I totally agree, Lorraine. And to add to your point, I think another benefit to running these lien searches ahead of time as a seller is you can also identify if there's any old registrations against the business or the seller, you know, that should have been discharged long ago because, you know, the loan has been paid off. We've run into this so many times, and, you know, in that instance, it can take a long time to discharge because you're no longer in contact with that lien holder, or, you know, they've changed, they've moved, they don't exist anymore. So that can be a timely process.
Yeah, that's a really good point. I've definitely faced that. I'm sure Karen has too.
Yeah, absolutely. So I want to say thank you to everyone. Before we turn it over to our audience questions, just a few last things. So far we've heard great tips about getting the business ready for sale. I did want to make a comment though and suggest that these are items that every business should be considering doing now, even if there's not a sale on the immediate horizon. So before we get to our audience questions, I'd like to turn it over to each of our panelists to provide any other recommendations or tips for businesses, whether they're contemplating a sale or you just want to use this time to tackle projects that will assist in running the business more efficiently or effectively once the pandemic is over. So Lorraine, maybe I'll start with you.
Yeah, sure. One thing a business can do is use this time to update its forms of customer and supplier agreements. For example, there may be provisions that are constantly being renegotiated by the other parties. And if you can go through and identify what those are and maybe create some sort of a handbook for your contracts that have typical clauses that are subject to negotiation, then you can establish what your fallback position is for those types of negotiations, so that the people who are out in the field negotiating these agreements on a day-to-day basis may, you know, be able to have a little bit of guidance as to where they can agree and where they can fall back, and that way you've got a nice little inventory of what those contract provisions are.
Yeah, and Karen, from a tax perspective, I'd say to the extent you've got any outstanding tax returns, just get those filed, even if they're nil returns. it's not super, and the reason I raise that is it's not super uncommon for someone who, for instance, has a holding company on top of several operating companies, and one of their operating companies may have been inactive for a number of years, but for whatever reason, they haven't dissolved it. But because it's been inactive and has got no income or entitlement to a refund, they simply haven't filed returns in respect of it. So any entities in your structure that have outstanding return requirements are going to raise red flags for a purchaser. And because if we back up for a second and remember that purchasers generally want to buy assets and sellers generally want to sell shares, we're already asking for a give. We want the purchaser to buy shares. And they might be willing to accept that provided that they can keep risk to a minimum. So things like outstanding returns are not something you want standing in the way of closing a sale and having a purchaser being able to kind of throw that back at you and either grind the price or delay closing, right? So that's a pretty simple thing that you can do. And once you've got all that stuff filed, the other thing I would say is it goes back to what Marcus has been talking about with respect to populating data rooms. Like, get all your stuff, all your returns, all your assessments, all your correspondence with the CRA, get it scanned, get it into electronic format, give it a name that makes it easily identifiable, and keep all that stuff in a folder in one place so that when your lawyer comes to you and says, okay, it's time to go, we need a folder for the data room, you have it, and you're not stuck spending, hours into the wee hours of the night trying to gather all your stuff and get it scanned at the last minute.
So I think it's also a great time right now to provide any training to your employees. Use this time to refresh some of your policies and procedures, particularly if there's been any updates since they've been hired. They may not have, outside of getting an email, been in tune to some of those updates to policies and procedures. And then if your company has, in-house legal department or has other professionals that, are subject to continuing legal or continuing education obligations, they should be using this time to, get on top of that and bank those hours.
I mean, on the employment theme, I think a number of clients had to let people go, and other clients are going to be looking to hire a bunch of people when this is all done. So people are looking forward at their workforce and doing some planning there. So not only is it important to identify the types of people you want to employ, but look at your employment agreements and your human resources policies and your manuals, and are they fit for purpose? Do they do what they need to do? To Lorraine's point, do those agreements relinquish any IP rights, especially if you're a tech company? So it's important to kind of look at that stuff and speak to the appropriate advisor there. And then, in relation to what I was saying earlier on, just pulling together a list of any regulatory permits in an Excel sheet or something that lists when they expire, who the regulator is, if you've got any designated individuals, stuff like that, that'd be really helpful.
Yeah, and just building on that, just one last point, Marcus, another thing that you could do is create a compliance manual that would identify any renewal dates for your business registrations or permits and any security registrations affecting the company. Taking inventory of your IP and determining whether you haven't actually renewed registrations or if anything should be amended. These things should, you should use sort of downtimes to look at these things because, there have been significant changes to the legislation relating to trademarks in particular over the last year.
Great, thanks everyone. That's all been fabulous advice. I think a common theme throughout is the more organized you can be at the outset, it really shows that the business owner has been a good steward of the business. And I would give a seller a lot of comfort that they can rely on your reps and warranties. And I think, as you said at first, and everyone's repeated it, the goal is keep as much money in your jeans as possible. So having that, showing that stewardship, gives people great comfort. All right, so before we turn to questions, I did just want to highlight our upcoming webinars in this series. Our M&A in Uncertain Times. So same time next week on April 28th at 1 p.m. Eastern is our next webinar on M&A deal dynamics post-pandemic. We also have a number of other webinars in the works, so keep an eye out for those announcements soon. And as I mentioned at the outset, last week we had our first one on the disruptive effect of COVID-19 on M&A transactions in Canada, and that webinar is now available on our website. So I do want to turn to some questions from our audience. I see that a few of them have come in, and there is time now if there are any others. So the first question that we have is about material contracts. So maybe I'll put this one to you, Melanie. As you spoke about material contracts before, one of our audience members is asking if you can explain what you mean by a material contractor. How does a business owner know what's material?
For sure. So a material contract is going to be a contract that, hits a certain threshold of either monetary value, unexpired term, the ability to renew, or, can it be terminated within a certain period of time. It will also be any contract that's so critical to your business that if it was terminated, your business would be substantially and adversely affected. In a deal context, the exact materiality threshold of time or money is usually pegged by the buyer, and it's tied usually to the value of the business. So, if the business is worth a certain amount of money, what's material to that business. But often for contracts that can't be terminated on less than 30 to 60 days, that's often what we see captured within this definition. And then, any contract that's essential to your business will always be caught by that term.
Thank you. Marcus, I have a question that I think is geared towards you. You mentioned earlier that the Canadian government has increased its scrutiny of foreign investments during this pandemic. Can you talk a little bit more about that?
Yeah, I mean, as I said earlier on, over the weekend, the government announced that it's going to be paying particular attention and additional scrutiny to any foreign investments, regardless of value, that relate to public health or involve the supply of critical goods and services to Canadians or the government. They're going to be taking a much deeper dive into foreign investments by state-owned investors, or even private investors that are closely tied to governments in foreign jurisdictions. The government noted that some of these investments might not necessarily be commercial in nature, and so that they could be harming Canada's economic or national security interests. It's interesting because the national security review powers are, notoriously ambiguous, and they can be quite broad. So to see that it's kind of been extended to take into account things in the current pandemic, and they're looking at public health and supply chains, it just means that buyers and sellers both need to be mindful of the fact that there's going to be additional information requested, maybe extension of timelines for review, which are all powers under the Act, and that this is going to kind of apply until the economy recovers, until after this COVID pandemic, which how long's a piece of string? We don't know when that's going to be. So it kind of just drives home what we said earlier on, that the more you know about your current situation and what regulatory permissions you have, if the government steps in and says, hey, we want to take a closer look at this, you've got the information to hand. And as we mentioned earlier on too, so some of you may know that if there's a notification required under the Investment Canada Act, you can file it up to 30 days after the closing of the transaction. But if we deem that it's a risky, or it's in an industry, or there are fact patterns that mean that the chance of a national security review are a little bit, more likely, if it's a defense product, for example, that the target company manufactures, then often we'll do a pre-closing filing 45 days prior to closing, because that 45-day window is the period of time the government typically has to put its hand up and say, hey, we have a problem. So if you file that 45 days prior to closing, the idea being that on closing, you've heard nothing, you're good to go. The government kind of reinforced this and said that they recommend, filing in advance. So it's just something that we need to be aware of, that the national security review powers have been kind of extended a touch, and that it's more important than ever to be prepared and anticipate, a 45-day closing period. Great,
thanks, Marcus. Another question that has come in relates to board of directors meetings. So the question is there any reason to keep the minutes of an annual board of directors meeting in the minute book? They say they only have one shareholder, being the U.S. parent. Lorraine or Melanie, do one of you want to take that one on?
Sure. I was just thinking, you know, if there's only one shareholder, you probably are doing your annual meeting of that entity by way of resolution. And normally, yes, that resolution would be included in your minute book, and it's proper to do that just from the perspective of a compliance, just showing that you actually are, you know, doing your annual filings and appointing the auditor or the accountant, or waiving that requirement on an annual basis, and electing the directors of the company on an annual basis. So those things should be reflected in your minute book. Any buyer would be looking for them.
Great, thank you. I see it's now 2 o'clock. I do have another 1 or 2 questions, so we'll stay on to answer those. But for those who have to drop off because of other time commitments, we did want to say thank you very much. We have appreciated the opportunity to discuss this topic with you. So until next time, please stay positive, stay healthy, and our very best to everyone. Thank you. So to our panelists, so the next question I have talks about the buyer's financer or the buyer's lender. And the comment relates to typically the buyer's lender also wants access to diligence. So the question is there anything in particular that a seller should be aware of ahead of time, or should do, for example, preventing the buyer's lender access to the data room, access to the seller's landlord's subordination agreements? Should a seller expect the buyer's lender to take a big role in the purchase process, and what can they do in advance? So anybody want to take a first stab at that one?
I can address it, I think. I think that a lot of the same issues apply even if it's the buyer's financer. Most importantly, I think in this situation, it's going to be the confidentiality obligations that we talked about in the material contracts. The buyer's bank may or may not be covered by the NDA that you have drafted. If it's not, or if there's any sort of uncertainty and you've got really stringent confidentiality obligations, you're probably going to want the bank to also enter into an NDA to make sure that you're not inadvertently disclosing information that you're not allowed to and then going offside your own confidentiality obligations. I think generally then they're probably going to look at the same information that the seller is, and all the other aspects apply in making sure that your records are all in order so that the buyer's bank also has the same confidence in your business.
Great, thank you.
I just, I know that this isn't exactly what we're discussing on the webinar today, but just it's a good segue. From a buyer's perspective, we talk about the buyer's financer. I had something that popped up in a deal where the buyer's lending agreement actually prevented them from having an earnout structure in a transaction, and we didn't find that out until we were about to sign the deal. And so then we had to completely change the consideration and the earnout mechanism to comply with their lending agreement. So I know we're talking mainly about sellers today, but a lot of the points you've raised kind of go to the buyer as well. And in particular, you know, take a look at your own financing agreements and make sure that the LOI that you're dreaming up with the potential target, are you allowed to do the financing or the consideration structure that you're putting forward? Is that prohibited under your agreement? It's just something that I think sometimes buyers overlook.
Great, thank you. So I think that's all we have time for now. So again, thank you very much, everyone. And hopefully we'll see everyone next Tuesday, same time. Thank you.
Thank you.
Take care, everyone. Thank you.
Thank you.